If you just want to start by giving a brief summary of what this child innocence bill is, what your goals are to accomplish with it.
It's actually two bills. Both relate to sort of the same subject, and that is the presence of obscene materials in our schools. A number of parents experienced during the pandemic was that they learned they were a little bit more in tune with what their kids were studying, what their kids were reading, what their kids were engaged with, and reported to me, and I'm sure many other representatives, their concern with the presence of obscene material in the classrooms or in their school libraries. So both of these bills are really come out of that as a genesis. They said, well, what kind of protections do we have? And so we did some research this last summer on, what protections do exist for kids and their exposure to obscene materials. And what we found is that the state statutes have a definition for what obscene materials are. And a lot of times people will ask, well, what do you think are obscene materials? And I said, well, I don't know how to describe it, but I know what it is when I see it. And the state has, I think, a good definition. In fact, neither of these bills address that definition. I'm comfortable with the definition as provided. But what we want to do with one of these bills, it relates to the Common School Fund, which is a fund that supplies library materials, school course materials to school districts throughout the state. And we want to make sure that that application of the definition of obscene materials is applied to those materials that are purchased with the Common School Fund. That's one bill. The other bill relates to, if you or I were to hand obscene materials to a minor, that's a crime, and we could be charged with that crime. However, it's not a crime if it's done by a school official. I understand that the origins behind that was to say we don't want to spend a lot of taxpayer money fighting with our school districts, and I appreciate that. But we did some digging to find out, well, what if we got rid of that exemption from liability, that immunity, if you will, that school officials have when presenting materials relative to the definition of obscene materials. If we got rid of that, what would be the protections that would be in place? Well, it turns out that there are already protections in place such that not only would a complaint have to be filed, but it would have to be filed with the local district attorney. And then the district attorney, after doing their research, would have to present that evidence to the state attorney general before any prosecution could begin on a school official. So there's already protections in place, which is a high bar.
You talked at length about the definition for obscenity, and I'm glad you did, because that's what I want to get into. Just for viewer purposes, I'm just going to briefly, read here, as per the legislative memo that accompanied this bill. It's something that, whether it's writing, picture, film, or other recording, that, quote, the average person applying contemporary community standards would find appeals to the, I'm not going to pronounce this right, the prurient interest if taken as a whole, that under contemporary community standards describes or shows sexual conduct in a patently offensive way, and that lacks serious literary, artistic, political, educational, or scientific value if taken as a whole, end quote. So that's the legal definition of obscene. And I think the question is, so many of those terms, who defines them and how do you define them? I mean, just take, for instance, what is contemporary community standards? That kind of hinges a lot of this definition. Who gets to decide what that is?
Yeah, I think you're going to have some variation across the state. We have 420 plus school districts across the state. I think each of those, if you will, represents the community. And that's where I think that discussion should take place. Whether it meets the community standards or not should be a matter of discussion at the school board level, certainly not at the state legislature level.
The definition was decided at a state legislature level at some point. However, do you know what year that would have been written?
I don't recall, but if you recall, what the definition refers to is that community interest, or that community understanding of what would be considered obscene. My guess is that, Madison might be different than Milwaukee, and Milwaukee might be different than Mosinee. I think that those communities in and of themselves would have the discretion to make that decision.
But this is a decision that would allow prosecution of a teacher, is it not? So let's say one community, I mean, perhaps they find a book that references LGBTQ people obscene. They're able to prosecute a teacher for that if they find that?
Well, again, this would remove immunity for teachers. I don't know why it's in the public interest to provide immunity to teachers or school staff for this very purpose of not presenting obscene material to our minors, our children. If you or I did it, it's a crime. If the teacher does it, it's not a crime. That doesn't make sense to me.
Right. But I think my question is who gets to define obscene? This definition, as you just said, leaves it up to communities. Communities can define it different ways. I mean, again, you know, there's been reporting about lists that have circulated among legislatures in terms of, you know, books that are banned. I think this bill potentially lends itself to, you know, removing certain books from libraries. I mean, at that point, again, what happens when a community finds one thing obscene, and that can mean very different things, and someone is prosecuted for that, but they wouldn't necessarily be prosecuted for that in a different community?
It's just like any other law that is enforced by law enforcement officials, including our district attorneys. There's a degree of subjectivity, which is why we have people involved in making that decision. I think that the prosecutorial bar is much higher in this case than any other case. I don't know of any other cases where not only would the case have to go through the local district attorney, but would also have to meet a passing standard such that the state attorney general would agree to the prosecution. So that's already a higher bar than any other criminal offense. I think we can remove the immunity with a feeling of confidence that we're not going to have spurious cases.
What are the types of books, the types of films in your mind that this bill is targeted to address? Can you give me some examples?
Well, I would rely on the definition of obscene based in the state statute, which is why we didn't touch that definition. I read that definition multiple times. I felt confident that it covered it. It's one of those things where, again, you know it when you see it, it's hard to articulate it. In the co-sponsorship memorandum, we point out an example that was brought to our attention where the description of how to provide oral sex was provided in, I think, a seventh grade library book. I don't think that definition or that characterization is age appropriate, and I don't think that should be in our schools. That's just one example. I'm sure many parents across the state of Wisconsin would be happy to supply you with many more examples.
So that's a description of a sexual act. I mean, would you find it problematic if a community such as Madison were to find the Bible violates obscenity because it has very many descriptions, very explicit descriptions of things like sexual violence and sexual acts?
Well, again, I would defer that to the local community. I think that I hope that they wouldn't find the Bible offensive, but I'm sure some people would.
It's well been, you know, reported nationally that teaching in general is suffering a lot of short staffing. It's going through critical shortages of both resources. They're very low paid. I mean, are there fears that this is just going to make that problem worse in terms of teachers being afraid of what they can and can't do and what their community might consider obscene or not obscene?
I don't think this exacerbates a problem that already exists. I don't think it makes it worse. I don't think a teacher's going to be reluctant to say, gee, I don't think I'm going to enter the teaching profession because I might be prosecuted by passing out obscene materials. Honestly, if they think that, they're probably not the best candidate to be a teacher in the first place.
All right. Thank you for your time, Representative.
Thank you. Have a great day.